Hi guys, if you come to this video, you must be a 1L and just got your first assignment about briefing the case. Don't freak out, okay? I'm going to help you out. First, I'm going to walk through how to read a case to begin with, and then we're going to talk about the important components of a case brief and how it can help you, and how those supplements that may be tempting to use won't help you in the long run. Let's get into it. Okay, let's start with first thing first. What is a case brief? Why is it important? And how it differs from, let's say, a court brief, right? So a case brief, what usually happens in law school is you're required to read court cases and then extrapolate important information from the cases and put it in a briefer format, right? So the idea of brevity rules is very popular in law school. So the law school professor is trying to test whether you can identify the issues in the case, the rule, the analysis, and the conclusion. What's normally known as IRAC in most cases. So the idea is to be able to distill a lot of information into probably 1 or 2 pages, if that. So that's the definition of what a case brief is when you're briefing in law school. When you're talking about writing a brief, which is different as appellate level review, that's not what we're talking about. And I know some 1Ls or new people can get confused about the difference between the two. One is actually briefing already a court case. The other, a court brief, is something that you submit to the court, basically on an appellate review. After something's been denied and you want to have appellate court review it, you have a brief that you write. That's not what we're talking about here today. So if that's what you came here for, we may do a video about that later, but we're talking about briefing an actual court case as one of the assignments that you have to help you. Is basically a study aid to get you information about what a case stands for and how you can use it in your in the law school career. So let's talk about that. Okay, so if you're a 1L, you probably had to buy this. I think they still require that. The Bluebook. I've had this Bluebook for quite some time. I've had several copies of it because it has like laminate on it, but it can kind of get worn out. So the Bluebook is going to help you in many of your first year assignments, but the Bluebook also tells you how things are cited, how cases are cited. And when you start reading a case, the first thing you're going to see is the citation. Who are the parties, whether it's plaintiff versus defendant, whether it's petitioner versus respondent, that's going to come first on the citation. And once you get familiar with it, you'll be able to read, you'll know which court it came from, the year it was decided, how to find the volume. All that information is kind of contained in that citation. So you start there, and that's how you would start your case. If you're doing a case brief, you put the citation. So let's say the case is Bank versus Wells. It'll have the citation, those names on there. It'll have the volume number, followed by, if it's a Supreme Court case, U.S., the first page of the case, followed by, let's say they refer to a specific section of the case, the specific page that you're referring to, and then the year that it came in. That only goes for Supreme Court cases. So they're very particular about how they cite things. So we're going to use that just as an example so that you can understand because more than likely your first cases probably will be Supreme Court cases. So we'll use that as an example. So you're going to put your citation at the top of the brief so that you know what this case is, referring to. Under that, you're going to actually start reading the case. And so to read a case, that's a whole nother thing, right? You have to read and understand what you're reading, and that's a whole nother ballgame. So when you're reading cases, you'll get real familiar as you read more and more of them. And let me tell you, you're going to read plenty of cases during law school and after law school. So when you get to a certain point, you'll know how to scan the case and look for certain information. You look for what the issue is before the court. What are the facts of the case? What is the rule of law they're using? The analysis? What is the holding? And if there are any dissenting and concurrent opinions. So I'm going to break down kind of each one of those briefly because those are all important when you're going to try to include them in your case brief. Of course, you're not copying and pasting everything that's said in the decision because that wouldn't make it brief. The idea is to say, okay, they said all this. What does this mean? This is a helpful, useful study aid for you because as you build your law school career, the cases will build on each other. And you'll say, oh, I learned this case from constitutional law. Oh, I learned this case from Civ Pro. You have to understand what the holding is so that you can apply it to whatever the situation is. So let's get into what I consider the IRAC method, but also has IRAC plus one in a sense, because it does add other things instead of just the typical issue rule analysis conclusion. Okay, so let's start with what the issue is. Usually a lot of judges write the same way. If you watch my other video about how to get a judicial clerkship, that is part of how judges, I got the experience about how judges write. A lot of them have the same format. It may have different spins on it, but they basically, when you look at their decisions, they're formatted in the same way. So it starts with the issue. What's before the court? Why are we here today? You need to look at the court case that you're reading and find out, why are they here today? What was the issue? And it may be multiple issues. And then you would list multiple issues if there are multiple issues. A lot of times people will want to say, okay, whether under when. So whether it is okay to do X under this statute when, and list the facts, right? So that's the typical thing that you can think about when you're trying to decide what the issue is, whether under when. It's not required, but it may get you in the habit of deciding, like, okay, what is before the case? What's the rule that, or the law that's being challenged here? And what are the facts that are being used to challenge this particular law? So that's what you would start with. And you would write that on your case brief. So under the citation, issue. And if it's more than one issue, you would do 1, 2, 3, or if it's just one issue, the one issue. So that's how you would start off. Usually, also what happens is you would list the facts very briefly. So, of course, the court has probably listed quite a bit of facts because there were quite a bit of facts involved. But when you're writing a case brief, you want to basically only extrapolate the important information that will help you remember when you look at that case again. So it's like, okay, when there was a guy who was driving and he was pulled over and the officers didn't have any reason to pull him over, blah, 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 right? So that would be perhaps your extrapolation of the facts so that you can remember it yourself and recall it for later. This is what happened. These are the facts. Okay, so then we move on to what's the rule of law. So oftentimes there is going to be a law that's being challenged. Like it might be a constitutional law, it might be a state law. Find out what law is being challenged. Usually the petitioner or the plaintiff's attorney is saying, this is what I'm challenging. This is how I should win based off of this law is going to prove me correct. So you have to kind of dig deep sometimes because they may list several laws within there. What's the law that's most applicable to the issue that you found in your above issue statement? What's the law that's most applicable? And list that. And write down what it says. Section 535 says that when a person is driving on a highway, they can be pulled over if there's probable cause and blah, 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 right? That'd be the law. So you would list the rule of law in your rule section. So remember, we're doing IRAC. There's some plus ones in between. So on the rule of law section, you're writing actually the law. The most juiciest and non-brief part of this brief is probably going to be the analysis. What has the court said? What have they said that kind of is going to bring them to their holding? Figure out how they arrived at their conclusion, because the holding is, okay, what did we decide? Are we going to say that this person claim is denied? Is the appeal affirmed? Is it reversed? That information is important. So the court's analysis, this is the court's reasoning. How are we walking through the facts, the rule of law, and how they're deciding how the facts apply to the rule of law? Do they agree? Do they feel like the facts should be applied to a different rule of law? That important part is what's going to help you understand how the court reaches its holding. And this is part of what the law professor's assignment is to you. They want to know, can you figure out how the court arrived at this? How they kind of told a story and decided, based on this story that they've told, this is why we come to this conclusion. So in that sense, I would say to be not as brief as you would for the issue in the rule of law sections. I'll say, so the conclusion, so IRAC, I-R-A-C, conclusion, C. That is the holding. What happened? What was the end result? Did the court say, if it's a Supreme Court, did they reverse? Meaning, we don't like what the lower court decided. We're saying that it doesn't apply, right? So send it back and say that, okay, we don't agree with what the lower court said. It depends on what it is. So some of it may be They affirm it. We agree with what the lower court said based off of the analysis we just made. But you need to find out what it is, because sometimes you'll make a, this is might be a rookie mistake, but you'll read the whole analysis, and then if you don't get the conclusion correctly, you could have it all wrong. Like, oh, these are the facts, this is analysis, and then they affirmed. And then the conclusion might be they reversed it. That's a big deal. So you really need to figure out what happened to say what was reversed. If they say reverse, what was reversed? That's when you go back to your issue. If the issue is whatever it is, what was affirmed? That's how you know what is the current law. If it's a Supreme Court case, which is precedential, meaning it applies to everybody, not just a particular state, you need to know what it is, because it goes forward as far as you understanding what the law applies when these particular facts come up. The Supreme Court has made this particular statement. Okay, before I get into the rest of it, I want to know, comment below, which law schools are you entering as 1Ls? Or you may be a 2L, or you may be a part-time student, whatever it may be, comment below, because I want to know. I'm kind of curious about who we reach out to. I know we get comments from people from all across the country, different law schools. Some of you may just be considering going into law school, maybe doing a summer program, and you had this assignment. I'm curious to know who we're perhaps helping in our TXC Tells All video, because we have things for pre-law, law school, and beyond. So make sure if you're not already subscribed, hit that subscribe button as well. The last part, usually if it's an appellate case and they have people on the panel that did not agree with the decision, but they were kind of like outvoted, you'll have a concurring or a dissenting opinion. And what this basically is are the judges that want to get their last little say so. It doesn't really apply to the case in particular as far as their reasoning in that sense, but it gives you a sense of what they were thinking about when they were deciding how they're going to vote on this particular case, right? Usually the dissenting judges are the judges that say, I didn't agree with this, but I was outvoted, so here's this. And it's like, okay, thank you, but that's not really the rule of law, but at least you can understand where they're coming from, because you'll notice kind of a trend with certain judges, how they vote when you see them again in another case, right? So this judge is mad, but they want to make sure they say their piece. Concurring opinion is like, I agree with what you said, perhaps on different grounds, but we arrived at the same result, right? So the analysis, they may not agree with the analysis, but they agree that the case should be affirmed or reversed, but they would have done it for different reasons. They want to have their say so as well. So it's basically dicta. Dictas mean like it's not law, but it gives you an insight of how judges think. And the law professors are going to want to know, do you understand what this concurring and dissenting opinion means? And to explain, because like I said, it may come up in a future decision. Okay, so hopefully I helped you guys who are trying to get this assignment done. I'll say a brief word about why you shouldn't necessarily depend on those third-party supplements that do have the case briefs in them, because I guess it will save you time in the future. But if you don't learn how to actually do a case brief, the whole assignment is to make you understand about how to appreciate and understand what a case law says, and to be able to figure out that information through that process. If you rely on somebody else who's already digested information, you may not grasp the information as clearly, and that will show when you go on the law school exam or even the bar exam. So I would caution you against relying on those third-party supplements to start with, at least. Not to say that they're not helpful when you're like 50 cases in and you're kind of behind and you need to know what's going on. They could be helpful then, but at first, when you're just trying to get to know how to read a case and understand what you're reading, I would say to do the work. Do the work yourself, and then kind of graduate to supplements as you kind of understand, like, I know how to read a case and I know how to brief a case. So good luck. Comment below if you want to have any other topics that you want us to talk about. We're here to help you out.